Welcome to another episode of the Influential Experts Podcast. I'm your host, Bobby Hicks, and today we'll be speaking with personal injury attorney Henry Queener, discussing personal injury law and compensation. Henry Queener is a highly respected personal injury lawyer with offices in Tennessee, Kentucky, and Colorado. He's one of the top 100 trial lawyers in the nation and has worked relentlessly to fight on behalf of his clients and recover millions of dollars in settlements from the big insurance companies. Now, over the last 2 decades, he's seen it all when it comes to personal injury cases and has agreed to be interviewed so that we could glean invaluable insights that could help us and our listeners avoid common pitfalls that could wreck our cases and recover the most amount of damages that we rightfully deserve. Henry, thanks so much for agreeing to come on today's interview.
Absolutely. Thank you for having me, Bobby.
Yeah, I'm really excited. So let's go ahead and dive in. Henry, I know a lot of attorneys charge an hourly fee. It's not uncommon for attorneys to charge $250 plus an hour. However, personal injury attorneys don't do that. They charge what is called a contingency fee. Could you explain what a contingency fee is and how it works as it relates to a car wreck case?
Absolutely. Yeah, you said $250 an hour. My goodness. I mean, some attorneys are $300, $400, $450 an hour. Contingency fee, that kind of sounds like a lawyery word. In most industries, I think they call it a commission. So I think of it as a commission. In law, though, we call it a contingency fee because the fee is contingent. So maybe it makes more sense to say contingency is contingent on the lawyer getting you something. So a contingency fee means the fee is contingent on the lawyer getting you something. So if the lawyer gets you nothing, then he has no fee. The ranges for contingency fees, I've seen down to like 20, 25%. I've seen as high as 45%. The percentage for a car wreck case depends upon the difficulty level of the car wreck case. It could be a basic car wreck case. It could be a commercial trucking wreck case. It could have an extensive overlay of state and federal law, so it gets fairly complicated. Depending on the complexity of the case, the contingency fee will be higher. So that's what a contingency fee is. Just think commission.
So when you see a lot of advertisements from attorneys that say no fee unless we win, that's what that means. It means like for you to meet with them, consult with them, look at their case, take on their case. They don't pay anything unless you're able to actually recover the money. That's correct?
That's right. That's right. We here at Queener Law will talk to you all day long for free on the phone, no fee. There's no fee until you sign up with us is what we call it. And then we have a contingency fee arrangement with our clients. We just, as attorneys in the legal profession, we struggle how to communicate this lawyery word contingency fee to people. And so we'll sometimes say, unless we win, we don't get paid, or we just try to figure out how to put it in plain terms people can understand. My best advice is just think of it as a commission. If there's no money at the end of it, though, there's no fee. So all the talking on the phone is free. Advice and consultation is always free at Queener Law. But if we get something for you, then we take a contingency fee.
Yeah, that's great. Are there any laws that regulate attorney fees in car wreck cases?
There can be. Great question. It depends on case types and location of cases. So there's some federal law that regulates certain type of cases and sets the attorney's fee or limits how much it can be in a contingency fee. There are some state laws in certain types of cases that limit how high a contingency fee can be. And I've seen in some states where in the state's rules of ethics for their attorneys, it sets fee structures and how much attorneys can charge for contingency fees.
How do these laws impact the fee structure?
So in some places, the law in some states, in some types of cases, sets an absolute maximum. The attorney cannot charge more than X percentage in a contingency fee. And in certain federal laws, it's setting an absolute maximum that can be charged a percentage. In some states where I've seen it in their rules of ethics, it's a very complicated structure where it's set out where it's, again, setting maximums that can be charged for certain sizes of cases. But I think generally people just need to know, generally, there's no law setting what the contingency fee has to be. and attorneys set that contingency fee based upon how complicated, difficult, challenging they anticipate the case to be.
Yeah. Your main practice areas are Tennessee and Kentucky. Is there a maximum limit in any one of those states?
Again, generally, no.
Okay.
But if you file certain lawsuits under federal law in Kentucky or federal law in Tennessee, there can be a maximum under federal law, but there's not a maximum for car wreck cases in Tennessee or Kentucky. But there are types of cases that you can file that involve car wrecks where there can be maximums. But generally, the answer is no, no maximum.
Yeah. Can you give me an example of an accident or an incident or a case that would be involved in the federal level where that maximum rate would kick in?
Sure. Most typically, we here at Queener Law in both Tennessee and Kentucky see that to occur when there's a car wreck with a postal truck. There's a lot of postal trucks on the road, and sometimes they have wrecks, and when they do, that is called a Federal Tort Claims Act case. In a Federal Tort Claims Act case, there is a federal law maximum of, I believe, is 25% that an attorney can charge for their fee. And so there's an example of you file a car wreck case in Tennessee, Kentucky, and you're having to do it under a federal statute. And inside that federal statute, it sets the maximum that the attorney can charge for a contingency fee.
Yeah, that's a great example. I don't think a lot of people really understand that or know about that.
Sure.
I know car wreck cases can be quite expensive. I know that you guys do a lot of due diligence and putting together research and reports to be able to argue on behalf of your clients. I know, for example, that your law firm uses accident reconstructionists to go and evaluate what happened during the accident. And that can be quite expensive. How are case expenses handled in car wreck cases? And who typically covers these expenses?
Yes, that is a great point. The expenses in a car wreck case can really run the gambit from a couple $100s to tens of thousands of dollars we've handled cases where the expenses have been hundreds of thousands of dollars. At Queener Law, we pay all expenses, but we do get the expense money back if the client gets money out of the case. If the client gets no money out of the case, they do not owe those expenses back to us. So it's kind of like the expenses function a little like the contingency fee in that we front all expenses. And if the client gets money back, then we get back what we fronted in expenses. But if the client gets nothing, then we at Queener Law do not get our expenses. We do not get the expenses back.
And that comes out of the settlement.
Correct. That does come out. Yes.
So it's not like, here's a settlement, the insurance company owes us this in addition.
Well, if there is no settlement, then we at Queener Law do not expect to get our expenses back to the client. If the client gets a settlement, then we get our expenses back out of the settlement.
So, for example, let's say that you charge a 30% contingency fee. So whatever the settlement is, you're going to get 30%. So you're going to take your 30% off the top, then expenses, or do you take, here's a settlement, here's minus expenses, and then here's the 30%? How does that work?
In my opinion, the industry standard is that the contingency fee comes off the top and then expenses.
And then expenses.
That's how we're structured here at Queener Law. The contingency fee comes off the top and then expenses. Let me just say that some law offices don't front expenses, and people should really be very careful if they're hiring a law firm that does not have the financial resources to front the expenses and handle the type of case you have. You better think about that. So some law offices would expect the client to put down a retainer that they would bill expenses against. That is not something we would ever do at Queener Law. And if you're hiring a law firm that does not have the financial resources to handle your type of case, that is certainly something you should think about.
Yeah, and that was going to lead into my next question. is it common for lawyers to front all these case expenses? And then how does that affect the overall cost?
I would say yes.
Okay.
Yes, it is common for them to be for law firms and law offices that do car wreck cases, do commercial trucking wreck cases to front all expenses. I mean, come on, Bobby. It's not reasonable to think that people are going to be able to come up with $10, $20, $30,000 or $100,000 to pay the expenses necessary to move their case forward and make their case against the insurance company and the trucking company. So it has to be common. Otherwise, people are deprived of the opportunity to make their case just because they can't afford it.
Mm-hmm.
But like I said, be careful about law firms that can't financially afford to front those expenses, because that would be concerning to me.
And these sort of law firms that may not have the ability to front these expenses would typically be what, your general attorney, your general practice attorney that kind of handles, they may do criminal, they may do family law, they do kind of a little bit of everything. Is that sort of where you would see that?
Even firms of all types are all different sizes. I'm just saying, whatever the office generally does, if it doesn't have the financial resources to front the expenses in your case, you need to think about that. So maybe personal injury is one part of what they do, and sure, that's fine. But if it's one part of what they do, but they can't afford to front the expenses to do it, you as the consumer need to think about, to be comfortable realizing that's what's occurring.
Mm-hmm. Well, let's say that you're responsible for causing an accident. And you and the insurance company, they're the ones getting sued. You guys are getting sued, not the other way around. And perhaps you can't afford an attorney to represent you. Is it common for insurance companies to provide you with legal representation at their expense, or is that on you?
No, that's why you need to have insurance. Please, everybody, make sure you have auto insurance, because no matter what the limits of the coverage are, the number one benefit of auto insurance is the insurance company will hire and pay for a lawyer by the hour to represent you. And so, no, you're not going to pay for your own lawyer. Don't be afraid to turn claims into the insurance company. Your insurance company has lists of providers who are professionals, who are going to do a great job for you. Turn your claims into your insurance company and let the insurance company hire and pay for a lawyer to represent you. And the insurance company, by the way, will also front the expenses. So as the attorney representing the person who's injured, I have to be financially able, I think, to front the expenses, because look, on the other side of the case, the insurance company is fronting the expenses for the person who caused the wreck.
The way I look at it is, are they really representing you, or are they representing themselves? Right. And you're just sort of that liability. I know that there's some exclusive rights that the insurance company has when it comes to settling a case that is, their client's fault. Could you kind of unpack that for us a little bit and kind of explain what rights that the insurance company has in regards to any sort of settlement from a case like that?
Sure, absolutely. So the attorney the insurance company hires to represent you, he only represents you. He's paid by the insurance company.
Okay.
He does have to give the insurance company information on what he's doing, because if they're going to pay him, they expect an explanation of what they're paying for. But the attorney the insurance company hires represents you. So you can feel free to communicate with him completely. He's not going to, let the insurance company know something you wouldn't want the insurance company to know. But you mentioned some exclusive rights in there. Most personal lines auto policies are set up such that the insurance carrier has the absolute and exclusive right to settle the case against you anytime they want to, for any amount up to the policy limit, and they don't have to tell you. And that can be very upsetting. Some people feel like, I wasn't at fault in this wreck at all, and I don't want my insurance company paying that other person any money here. Well, it can be upsetting to find out the insurance company did pay them money, because that's the insurance company's prerogative. They evaluate all the facts and circumstances, carefully consider likelihood of success or failure, and then what's called adjust claims, and they pay them. And they don't ask you or permission to do that when it comes to personal lines, auto policies, or just regular people's auto car insurance.
And I guess one of the reasons why that could be upsetting for someone is because, they feel like they're the victim. They don't like to see someone else getting, technically rewarded when they feel like they've been, victimized. But also, I think a lot of people fear that it could raise their insurance premiums. They feel like they are not at fault. And now this person's, it's kind of like you're paying for them. You're kind of admitting guilt, like it was your fault. And they're afraid that, they'll get their insurance premiums increase. Is that common? Is that typically what happens?
I can't speak to the process that gets your insurance rates to go up, but it is common that your insurance company will settle your case, the case against you, and will not communicate or tell you that they're going to do that. They may go to certain processes or meetings with the other side where the case is settled, and you won't be invited to them or even told they're taking place. And so your insurance company will not consult with, it's not common for your insurance company to consult with you or tell you when or how much they're going to pay on a claim. You just generally, if at all, find out after everything's already done.
Yeah.
And then it can be very upsetting, but it's all done now, and the insurance company had the absolute right to do it.
You said earlier that if the accident was your fault, you can choose, which attorney you want to represent you. Is that like a list that's provided to you from the insurance company? Like you can only use an attorney within their network, or could I go to any attorney to represent me in regards to my at fault case?
Generally, the way it works is the insurance company just assigns an attorney. That attorney contacts you, and that attorney represents you. So that's generally how it works. But if you don't like the attorney is, and you are not getting along very well, personality clash or whatever, you're more than welcome to call the adjuster at the insurance company and say, this attorney is not working out. I need another attorney who's on the approved provider list. But all insurance companies are going to require that an attorney who's been vetted to handle claims, files that they're given by that insurance company, handle the case. So if you don't get along with the attorney who's assigned to your case, just call the adjuster, let the adjuster know that, and the adjuster will give you the name of another attorney you can give a try. But you're going to have to use an attorney who's been vetted by the insurance company. You can't just go use a friend of yours or someone you know from a social organization or church or something like that.
Yeah. How does the exclusive right of the insurance company to settle the case affect my involvement?
Well, this is very important, Bobby, very important. You've got to cooperate in your own defense. So some people go, well, it's the insurance company's money and the insurance company's going to pay it willy-nilly and not talk to me anyway, so I don't care. I'm not going to have anything to do with this. Do not do that. You are required in the insurance policy to cooperate in your own defense, which means you need to answer the insurance company's phone calls or return them. You need to talk to the attorney they assign to your case, give the attorney they assign to your case the information that attorney asks for. That might involve filling out some paperwork. The attorney assigned to your case may need you to come give a statement in person. You need to show up for that. If you want that insurance money, that insurance policy available to pay for what happened, you've got to cooperate with the insurance company and with the attorney they assign to you, even though it stinks that at the end of it, the insurance company has the absolute and exclusive right to settle your case for however much they want to, up to the policy limit.
Well, Henry, that's all the time we have for today. Thank you so much for agreeing to come on today's episode and share your invaluable insights on personal injury law and compensation. For our listeners, we hope you found this discussion informative and insightful. If you did, please let us know by liking, commenting, sharing this episode with others. And if you live in Tennessee, Kentucky, or Colorado, and you'd like to hire Henry and his team that represent you in your personal injury case, you can reach out to him by searching Henry Queener or Queener Law on Google, or you can visit him directly at his website at queenerlaw.com.